certainly have fears that there is a serial killer at loose in Perth.
Sarah Spiers, Jane Rimmer, Ciara Glennon.
And every time you saw a young girl walking by, you think, oh God, is she going to be the next victim?
Now, one man stands accused.
If police are right and Edwards is the Claremont serial killer, he's been hiding in plain sight for 20 years.
Bradley Robert Edwards is the Claremont killer, but not a serial killer, having been cleared of murdering Sarah Spiers. Hello and welcome to this bonus episode of Claremont in Conversation, The Verdict. Natalie Bongiolo, Tim Clark and Alison Fan with you, and welcome back to leading criminal law barrister Tom Percy QC. Tom, can we start with you? Can you see any way that Justice Hall could have found Bradley Edwards guilty for the murder of Sarah?
Well, quite easily. He had an exhausting look at the propensity evidence, but found at the end of the day there are insufficient similarities to enable the factors relied upon by the prosecution to have any significant probative value. Now, I won't bore you with what the law is in that regard, but in recent years, the law in relation to propensity evidence has become somewhat narrowed. So he was bound to some extent to the extent to which he could apply that in favour of the prosecution case in respect of Sarah Spiers. But if you have a look at an article I wrote this morning in the West, it's on page 11 of the wraparound, I isolated 8 issues which he found adverse to the prosecution. I mean, on one superficial level, if you have a look at the judgment, say, oh, well, he's embraced the prosecution case where there was a body. Well, the fact is he hasn't. There are a number of issues put forward, the Wellard screams, the Mosman Park screams, the sexual motive, the criminal pattern, identification evidence and things like that, which he rejected. Now, the prosecution might have thought they were unlucky there, and they stood a good chance of getting a conviction on Sarah Spiers if he'd embraced any of those. And they may well want to chance their arm in an appeal.
So can you just explain for people the legal reasons behind the acquittal?
Well, it just wasn't satisfied beyond reasonable doubt. He looked at everything that the prosecution had brought up, everything they said supported their case. He liked some of it. He didn't like some of it. The parts that he liked weren't sufficient to get him over the line beyond reasonable doubt. It's as simple as that.
Yeah. And Justice Hall said that Edwards is a likely suspect or even the probable killer. And I think for many people and for those people who aren't in the law, it might make this verdict a bit of a difficult pill to swallow.
Well, that's what the onus and standard of proof is all about. And the lay people sometimes have difficulty coming to terms with that. For instance, a lot of civil cases are decided on the civil standard, and that's the way the judgment goes, and there are major ramifications when something's proved on the balance of probabilities. Beyond reasonable doubt is a much higher one, and that's the standard that's always been applicable in criminal cases, and that's the standard that Justice Hall applied.
Tom, do you also think maybe he just didn't want to open any other areas for maybe grounds for appeal if he'd found something on Sarah Spiers?
I don't think that really would ever come into his consideration, Ali. Now, there's always a possibility that he might appeal anyway, and then he might not agree with the way in which the propensity evidence was used in support of the Glennon case and the Rimmer case. He might not like the fact that his challenge to the DNA evidence was not accepted. He might not like the analysis of the fibre evidence. There's plenty of fertile ground upon which he might want to appeal. And I don't think any judge, when they sit down to write their judgment, does it with a weather eye to an appeal.
619 pages. I mean, there would be plenty of material to mine through, and it only takes one line of in a jury trial, for instance, one line of a judge's summing up can bring the whole the whole pyramid of cards sort of crashing down. But as we've discussed previously, yeah. I mean, we've discussed it though that Justice Hall is meticulous. He showed that in court, and he's shown that in previous judgments. But yeah, I'm sure Mr. Jovic and all his team will be sort of scouring the thousands of paragraphs to see if there are possibilities to maybe get a foothold somewhere on the big mountain that is an appeal.
I don't think that they would really need to go trawling for the same sort of technical issue or infelicitous turn of phrase that might have led to the appeal being upheld in Wark's case. I think that's what you're talking about,
Yeah.
the Haley Dodd case, and it's not unique to that. I mean, sometimes that happens. But I would think they may well want to mount a challenge on the basis of the findings, the critical findings, the three critical findings: 1, DNA; 2, fibre; 3, Karrakatta, and how the judge used those. Now, my initial impression is that they seem to be fine, but others more learned than me may well have a difficulty with them.
No, there's no one more learned than you, Tom. Come on.
And what about an appeal from the prosecution side?
I reckon as we sit here and speak, that's what will be going through their minds. I really think right at this very moment they're probably sitting down at the offices of the DPP and poring over those judgments and saying, how do we miss out on so many points? And is the result of that the acquittal in relation to Spiers?
Would there be any incentive or any reason whatsoever for Edwards to speak up? Obviously, there's been calls for him to come forward if he has any information about the whereabouts of Sarah. What would be the incentive for him to do that?
Well, that question is predicated, and it's a loaded question, that A, he was responsible for a death, B, that he knows where she is, and the answer to that is no. There's absolutely no incentive for him at all. He's probably never going to get out, and having 2 murder convictions against his name, I don't think there's going to be much difference for him in relation to the other one. Nothing at all, and I don't see any government at any time or any Attorney General doing a deal with him.
I unfortunately concur there because on top of that, Mr. Edwards has shown plenty of propensity in other areas, but absolutely no propensity to own up to anything he's done apart from the Hollywood attack. And he was literally caught in the act. There was a security guard on him within 15 seconds of that attack. I
think that's probably a little unfair. He did plead guilty to Karrakatta.
No, that is true. That is true.
4 years down the track and following a conviction, may he have a change of heart, just as he did in relation to the Huntingdale and Karrakatta? And the answer is possibly, but the question you asked was, is there anything in it for him? And the answer is no, there's not.
No. And if there was, we talked about this yesterday in the podcast about this idea of double jeopardy. If police have said that they will not give up on the search for Sarah, if there was some sort of compelling evidence to present itself, what would be the possibilities of those charges to be heard fresh? Well,
there's no impediment to that whatsoever. The law changed. Parliament changed the law there a few years back. I don't think it's ever been utilised yet, but if, let's say, they found a body and something linking that body to Edwards, they'd be in the Court of Appeal quicker than you can say Jack Robinson.
Yeah.
And the police commissioner was asked directly about that on radio this morning and said, as he said yesterday, the case is open, it will remain open forever, and those double jeopardy laws were changed and are in effect and could be used if we had access to the fresh and compelling evidence to be able to use them.
Yeah. So today, Ciara's dad, Dennis Glennon, gave a press conference. This is a little bit of what he had to say.
When Ciara was deemed a missing person, I appealed for help to find her in a press conference like this, in this very same room. And through tears, I said she would fight for her life because of the way she was brought up. She would fight for her life. And little did we know then how prophetic these words would be. As she fought to save her life, she left us the vital DNA clues. Ciara was strong in spirit, had courage, great courage, but yet as she fought to save her life, she could not save herself because of the brutal assault by her murderer.
Ciara, as we know, was a lawyer, and I guess, some people have suggested that when she scratched Bradley Edwards and when she fought for her life, that she knew exactly what she was doing and how important it was or could be.
Well, you'd hope you'd be as clear-eyed and clear-thinking as that, but from what we know from her injuries and the scene where she was found, and now Justice Hall has found that she was more than likely killed at, I get the impression that it literally was just that. It was a fight for her life, with a hope of not leaving behind any possible evidence, but in the hope of getting this man off her, so she might be able to escape and survive.
Because back then the DNA was, as we all know, in its infancy.
Yes, it was. And we also know that the technology didn't exist for another decade and a bit to be able to find it. And even then, a decade on in the trial, the technique that was used to find it was still being argued over and contentious. So, as Dennis said there, either way, whether she was thinking about it clearly or thinking about it candidly, in that I'm in the fight of my life here, the DNA was there, and it was found eventually, and it led to Mr. Edwards' door eventually.
Tom, what do you think the ramifications are to have this verdict so long after the fact, based a lot on this DNA? What are the ramifications of future cases, historical cold cases?
Well, there's always a chance, isn't there? It just shows that it's probably never too late. And I think it shows the benefit of preserving the evidence from an early stage. You might not have anything that at the time leads anywhere, but may form part of a jigsaw puzzle a decade, 2 decades later. And I think we're probably going to see more of that as time goes on.
Because even though we did hear about a lot of problems with Path West, it seems that they did enough right that and kept and preserved it that has brought this case about.
I think that's right. I mean, as I was watching the DNA evidence materialise in the case, there were problems, and I think the prosecution has done a very good job to be able to salvage that evidence and convince the court that it's intact.
Yeah, I again concur there. There was so much work done by the prosecution to produce the timeline from when Mr. Edwards' samples first got in the lab to when Ciara's samples got in the lab, and eventually we're able to show that never the twain did meet, and in fact show the amount of time between those samples being analysed out on a bench somewhere. Eventually it proved to be good practice, and we heard a lot from Scott Egan and other Path West scientists that obviously they never deliberately went out to contaminate, but at the time they were doing it, they were practicing in the best way that they knew how to do then. It might not be the way that they would do it now, certainly not. And we saw an evolution, I suppose, of a timeline of how the forensic practices have developed over the years. And something Commissioner Dawson said on the radio this morning took me back to the photo in the paper of the kimono that proved to be the final piece in the jigsaw. The policeman holding that kimono up for the photographs was not wearing gloves, was not wearing a smock or a tunic or a mask or a hat. It was just him and his farras and his polo shirt holding up the kimono for the paper.
But Paul Ferguson also reinforced too, didn't he, that there was sort of some, even though they'd never heard of cross-contamination, there was some innate thing in them that they knew certain things had to be done. They didn't understand, but they knew that they had to preserve it a certain way, and fortunately that was what happened.
Yeah, as he said to us both, Ali, when we interviewed him, he is of the very firm conviction that what his team did in the early days in 95, 96 laid the foundations for the rest of the case in terms of best practice, or in terms of the best practice they knew how to do at the time. And from what we heard in the trial, that is right, because there weren't any issues really, certainly at crime scenes. There were some ideas floated that there might have been some contamination there, but nothing that came anywhere near being a major stumbling block for the prosecution.
And today, 24 hours after the verdict, Mr. Glennon was absolutely emphatic about his praise for the scientists and people who worked on the forensic side of things over the years, and including those honest mistakes.
My family has no criticism of what the police or the scientists might have done better during the very lengthy investigation. We have no critique of those involved. They did the very best they could with the information, with the methods, with the equipment that they had available to them at that time. And nothing revealed in the trial came as a surprise to us. Nothing, including the honest mistakes.
Yes, look, it's all very well to go on and throw a lot of accolades in the direction of the police, but sometimes I don't think we should lose sight of the fact that for some years they effectively put down tools because they thought they had their man. Yeah, and the terrible, terrible damage they did to that man and his family is something that seems to have flown under the radar in them basking in the glory of their convictions yesterday. And I don't say that in a mean-spirited way, but it's something I think we should never forget.
No, you're absolutely right. Yeah. Tom, we've talked about Lance Williams on the podcast numerous times. He was put under the most scrutiny probably of any suspect that ended up not being charged in Western Australian history. He paid an immense price for that personally, as did his family, and he died before he could actually see his name officially cleared, even though de facto he was told that he wasn't a suspect anymore after Mr. Edwards' DNA, or the unknown male 4 DNA, came back from the UK. And then obviously when Mr. Edwards was charged in 2016, that was another step to his rehabilitation, I suppose, in the public light. And I noticed today in the Post newspaper, his mum Norma, who's still alive, she's in a nursing home, she's 87 now. She said, again, reiterated what the effect of that scrutiny, of the effect of that publicity had on her and her son and her husband, who died. So Lance's father died less than 6 months after Lance did. So, that Tom's absolutely right, and there is no brushing that out under the carpet. That is a stain. That is a stain on the macro investigation and the investigators who were leading that part of that investigation at the time.
We asked the WA Police Minister this morning whether the state should make a public and formal apology to the family, and she mentioned that Police Minister at the time, Carlo Callaghan, had. But do you think there needs to be something more done about this?
Well, I do, and look, he's not the only one. Over the years, I've had to act for a number of people whose names have been thrown up in relation to this, that the West and certainly some suburban newspapers have been very happy to run with as being a suspect. But one of them in particular didn't want to give his DNA. They thought that was a sure sign of guilt. These are people who were well known in the Claremont area at the time. And those people's lives will never be the same, as being the shadow of guilt having been cast upon them in relation to this matter. So it's not just one person. This investigation, although they're happy just to take all the accolades yesterday, has had some peccadillos, and I can tell you that those sort of things won't be forgotten by a lot of people.
The defence attack on the DNA was intense. Tom, do you think the fact that they couldn't actually pinpoint moments of contamination was the problem?
Not really. I think it's just a question of scientific methodology. Some people have different views about it. Some people would have been appalled by what happened. It's like that in any scientific method investigation. You can call two experts from the other opposing sides of the fence, and one will say, oh, this is terrible, the results here are worthless, and other people say, no, that's fine, that's intact. And obviously the defence in this case had interviewed a lot of people who had serious reservations about some aspects of the scientific process and the DNA results, whereas the prosecution were able to have some other experts who could defend the practice and the integrity of those results. At the end of the day, that was the version that appealed to the judge.
Tom, you've seen a lot of defendants in your time. Have you ever seen anyone like Edwards whose demeanour has not changed from, it's almost like he's detached, like he's in a parallel universe when some of these fairly gruesome details have been read and throughout the whole trial? He's just not shown any emotion apart from a very slight shaking of the head at the very, very end.
Oh, look, I don't find that unusual at all. Quite frankly, the longer you're in jail awaiting your trial, the more you get inured to this sort of thing. And by the time the trial was approaching, he would have been numb. None of it held any meaning for him. And at the end of the day, what was the outcome? I mean, there was no glittering prize for him. He wasn't going to walk out. He's got a lot of axes to grind yet, and there was not much in it for him. I can imagine he wasn't that interested in it. And yes, the answer is yes. I've had a lot of clients like that.
But even right from the arrest, it was a very bland reaction.
Sometimes you get that.
Okay, so do you really think he knows where Sarah Spiers is buried, or do you think he is, again, in another world?
Look, I don't know. I've long since giving up trying to work out whether people are or are not guilty. I just look at the evidence. I agree with Justice Hall. There's not enough evidence to support a conviction, and who am I to second-guess that?
And when they do the psychiatry reports, will that come out public, or was that kept in?
I think a lot of that will be referred to in court if they make out if they isolate any problems. I'm sure his defence will raise that openly in court. I don't think that will be suppressed. I'm not sure they're going to give us all copies of it, but the issues that they think are of any relevance will be pointed out in open court. I think both the prosecution and the defence, they'll all have their own spin on it.
Yeah, I mean, I think obviously the outcome yesterday for the community was, I think for many people, an enormous relief. But I think what you're telling us is, this hasn't run its race yet.
Oh, look, I think yesterday was a milestone moment, but if I was Tim and I was writing the book, I'd keep a few blank pages at the end.
Yeah, they are blank and will remain so for a while. There was, as Tom says, a chapter or two was written yesterday and today. Dennis's words today were gentle but so powerful. You could have heard a pin drop in the press conference for 20-odd minutes, and some very experienced senior police officers puffed out their cheeks after Dennis had gone, because it was quite an intense moment hearing him speak so eloquently about his daughter in the same room that he'd made the appeal for information about his daughter all those years ago.
Yeah, look, he's an impressive individual, and I think he'll be one of the main memories that people will have of this case in year gone by, him and his family's bravery.
But with the appeal process, we could be sitting here next year, could we, Tom?
Oh, indeed, yeah. Look, I'm running a wrongful conviction appeal in Tasmania at the moment, and it's just gone 10 years since the woman was locked up. So, these things can go for a long time.
Extraordinary. And, as we kept saying, there is nothing ordinary about the case, but then it is the most ordinary case, as Justice Hall was mentioned yesterday in his opening. Well, thank you all very much for your time. And as always, you can read more in the paper tomorrow or online at thewest.com.au. Ali, Tim, Tom Percy, thank you again. We'll be back Monday with some more analysis and answers to your questions. For Claremont in Conversation, The Verdict.
This podcast is hosted by Natalie Bonjolo, produced by Kate Ryan, and recorded in the studios of 7 West Media. Sign up for daily emails and all the latest on the Claremont trial at thewest.com.au. And if local news delivered differently appeals to you, tune into WA's newest morning show, The West Live with Jenna Clark. It's talkback radio, but without the interruptions. Listen live weekdays from 8:45 a.m. on thewest.com.au or catch up with the podcast.